Good morning, everyone, and welcome to the ENS Africa webinar, Mines and Vaccines, the Next Step. We are excited to be hosting this webinar during the week of the mining Indaba. We will be discussing such an important topic in the middle of a pandemic. We will be hearing from various experts in the different practice areas to share some thoughts on the legal, health and safety, employment challenges of vaccination in the mining industry. My name is Nzigi Adonisikhame, a partner in the Natural Resources and Environment practice. It is a real pleasure to be facilitating this interesting discussion on the mines and vaccines. We have 4 panelists who will present for 10 minutes each. This will be followed by a question and answer session. So kindly pose your questions in the Q&A box, which will be answered at the end of the presentation. I have the pleasure in introducing our first speaker, Willem Leroux, a doyen of mine health and safety in South Africa, and the author of a leading publication in mine health and safety. He will share with us and give legal perspective on how mining companies mitigate and manage the risk of the spread of COVID-19. Over to you, Willem. Willem, you're on mute.
Oh, God. Yeah, thank you, Nzigi. I'm going to deal with risk management and the relevance of risk management in relation to vaccination once the medication is available. Now, that's very important to see that in the correct light. Yesterday, it was published in one of the electronic media, the following. It says, once the vaccine is freely available, mining companies may decide to provide vaccinations to protect employees' health and safety at work. In terms of current mine health and safety legislation, there is, however, no legal duty on mining companies to do so. Now, that is wrong, what is stated there. Whether or not there is an obligation to provide vaccination once it is available depends on the facts and the law. So let's first have a look at the law. There we refer to Section 11, Section 12, Section 13, and Section 22 of the Mine Health and Safety Act. Section 11 deals with risk management, with the obligation to identify hazards, to assess the risks of the hazards occurring, and then to record significant hazards and risks. That is what 11.1 says. So you determine what's the hazard. We know what's the hazard. It's COVID-19 and possible variants and so forth. And the risk is the likelihood of that occurring in the workplace. Okay. Then secondly, as far as mitigation measures are concerned, there the Act says that every employer, after consulting the Health and Safety Committee, must determine all measures, including changing organization of work and design of systems of work, necessary to eliminate any recorded risk, control the risk at source, minimize the risk which remains, and provide personal protective equipment, and so forth. So it is important to note that as far as the mitigation measures are concerned, the requirement is that it must be necessary, not just reasonably practicable. And necessary places quite a burden then on somebody who alleges that you must do it. So it must be necessary and not, merely convenient in the workplace. So that gives some protection to people who demand perhaps too much in the circumstances. Now, Section 11 must be read with Section 13 and 12. And up to now, in the mining industry and also elsewhere, to a great extent, focus has been placed on Section 13 and the medical surveillance, the medical side of the disease. Now, in terms of that, you must do medical tests from time to time, determine whether an employee is fit for work and so forth. And you must take into account, of course, the report that you receive in terms of Section 12. Section 12 deals with the employer's obligation to conduct occupational hygiene measurements. Now, that's very important, and that sometimes is forgotten because it's all about the work environment. Is the work environment safe as far as reasonably practicable and not hazardous to health? So that's very important. You must ensure that what you are providing in the workplace is air of an acceptable level, not a recirculation of rotten air. So look at your ventilation systems. That applies to offices, venues where inquiries and investigations are being held, the underground situation. And of course, you must have a conspectus of all the relevant things that you provide in the workplace. You look at the social distancing between employees, the requirement of washing hands, the requirement of screening before people go underground, and so forth. And one of the measures that will be added to that will, of course, be vaccination once it is available. So if we now deal with the facts, we've dealt with the law, now we deal with the facts. If government allows employers to obtain vaccination, then of course that will have to be considered as part and parcel of the mitigation measures. And whether or not it is necessary to provide it will depend on the facts. After you've applied Section 11, 12, and 13. And you must also take into account Section 22, because 22 says that you as employer must take reasonable care for the health and safety of workers, and the employees, they must also take reasonable care for their own health and safety and the health and safety of others. And that must also be taken into account together with Section 24 of the Constitution. That section is more or less a repetition of Section 22. It says that everyone has the right to an environment that is not harmful to their health or well-being. So that's why you must take all these steps. But whether or not there is a legal duty will depend, in other words, not only on the law, but on the facts. So particular people may have a right to vaccination if it is available, depending on the result of the Section 11, 12, and 13, read with Section 22 provisions. So if the chap is over 60, and if there are comorbidities, and if the person works in a hazardous environment, then probably it will be necessary for the chap to be vaccinated or even withdrawn from the workplace. So that's an important issue. Now let me just see whether I'm still on time. A number of other statements were also made in this electronic communication yesterday. It says, if mining companies were to tell their employees they may not come to work unless they have been vaccinated, they would potentially be violating various basic human rights enshrined in the Constitution, including the right to bodily integrity. So if this is correctly reported, then it means you can't even tell a chap he can't come to work unless he's been vaccinated. Now, that is not so. But your work rules, and Balindile, she's going to deal with that. Those rules must be valid and they must be fair. Then you can tell the chap you must be vaccinated if the relevant circumstances, the facts read with the law, if that determines that in order to ensure safety and health as far as reasonably practicable, the person should be vaccinated. Then you can tell him he cannot perform the work provided, if he's not vaccinated. It's similar to a situation of a chap who becomes deaf, and he has been a loco driver. And now he can't comply with the Dover test requirements. He can't determine what is happening in his circumstances, and he becomes a danger for himself and for employees. Same thing. You apply the facts to the law, and the same will have to be done in this particular case. So one must be careful not to read all these things out of context. And in any event, together with that constitutional right to bodily integrity, there are a number of other constitutional dictates which are important, specifically also section 24, to which I've referred to, that that everyone must everyone is entitled to an environment that is not harmful to their health and well-being. So that includes the employer. The employer must take steps to ensure that the environment is not harmful to the person's health or well-being. And so one step will be to ensure that people who are in the position to endanger others should not be allowed to work. And if they insist not to adhere to the rules, then of course certain steps in terms of employment law can be taken. Balindile may deal with that. Yeah, thank you, Nsiki. I think that brings me to the end of my 10 minutes.
Thank you very much, Willem, for your insights. I have a pleasure in introducing our second speaker, Pieter Colleen, the head of the Mine Occupational Health and Safety and one of the leading mine health and safety lawyers in the country. He will give an input on the practical implications of what the prominent mining companies are already doing. He will consider their future plans and the possible measures by the Department of Mineral Resources and Energy. Over to you, Pieter.
Thank you very much, Nsiki. It's always a privilege to address the mining community and a privilege to advise the mining community on various aspects pertaining to what's happening in South Africa. And today I'm just going to share and give some insight into some of the practical implications, looking at what certain of the prominent mining companies are already doing and their future plans. And then very important to also look at what might happen if the Department of Mineral Resources and Energy start to exercise its powers in terms of the legislation. Now, all of this will be focused on the vaccination process and the role that it will play. What is important is, as a starting point, just to set the scene, to look at the guidelines that were issued by the Chief Inspector in terms of which mandatory codes of practice are required on the mitigation and the management of the COVID-19 outbreak. And it's important, to look at the objective of that document. The objective of the guideline and obviously the codes will be to assist employers as far as reasonably practicable to establish and maintain a COVID-19 prevention, mitigation, and management program at mines. So already within that framework, it's also recognized in terms of the guidelines that there's going to be a lot of new developments, that there's going to be, and that the guideline and the code of practice have to be regarded as almost like a living document, because the whole time the guideline must be considered as a living document, which maybe need to be updated as new developments on the prevention and management of COVID-19 emerges. As we sit now at a stage where increasingly we're going to see a rollout of the vaccination program, obviously that guideline will also align itself in terms of those programs, and the codes of practices will be aligned. What is unique in the mining industry is the fact that the mines already have various protocols and procedures in place to deal with the mitigation and the management of COVID-19. And they have a lot of facilities and infrastructure. And if I look at these facilities, it is focused on primary and also occupational health care. And then also what is also a huge advantage in the mines is the fact that there's an advanced electronic database in respect of employees. And, you know, that's driven through a clock card system where employees clock in and report for work. So all of these infrastructure, electronic database capabilities of the mines put them in a very unique position that they can play, in a very good position that they can play a big role in the vaccination of their own employees, also to possibly look at the vaccination of the dependents of their employees, because already they have a vast amount of information available to assist them in that process. So what we're already seeing is that a lot of the mining companies are putting themselves and positioning themselves so that they can put themselves in a position that they can support the government in the vaccination processes that will be rolled out. Now, if we start to look at all these obligations, it's important, you know, just to again look at it from a statutory point of view. And there's the provisions of Section 5 of the Mine Health and Safety Act, which places the obligation on the employer to maintain a healthy and safe mining environment. Now, the obligation in terms of Section 5 is twofold, as in that the obligation is imposed on the employer to take, as far as reasonably practicable, to provide and maintain a working environment that is safe and without the risk to the health of employees. But it also goes further to say that as far as reasonably practicable, every employer must identify the relevant hazards and assess the risks to which persons who are not employees may be exposed, and also to ensure that persons who may be directly affected by the activities at the mine and who are not mine employees are not exposed to any hazards to their health and safety. And as Willem has already indicated, you know, all these obligations are then driven through a risk-based approach that also comes out of the guidelines, and that's obviously in terms of the law. And if we then start to just look at this obligation imposed in terms of Section 5, the words "as far as reasonably practicable" is utilized. Now, it's important to see that against the background of what's meant with "as far as reasonably practicable." There you have to look at the severity and the scope of the hazard or risk concerned, the state of knowledge reasonably available concerning that hazard or risk, and of any means of removing and mitigating that hazard or risk, the availability and suitability of means to remove or mitigate that hazard or risk, and the costs and the benefits of removing or mitigating that hazard or risk. And again, in assessing the performance or the compliance of the mine, our courts have used the standard of the reasonable person as the criterion to determine the reasonableness of conduct. And that's going to be an important aspect if the department will be starting to invoke their powers in terms of, like for instance, Section 54 and 55, to then start to look at the reasonableness of the conduct of the mining companies in the steps that they take to mitigate and manage the spread of COVID-19 at their working places. And again, you know, if you look at those steps at this stage, the steps obviously will include social distancing, wearing of masks, hand sanitizing, reducing number of persons. But as Willem indicated, you know, in certain instances through that, the process and the risk-based approach, it may be determined that it's appropriate to also apply the vaccination process, or to, you know, to apply that in respect of certain employees. Now, if we look at the inspectorate's powers, the Department of Mineral Resources and Energy with their inspectors, you know, the starting position is that in terms of Section 50, the inspectors have wide powers to actually visit working places, to question persons, to require the production of documentation, and then also to inspect arrangements made by the employer for the medical surveillance of employees. And out of that, you know, in the mining industry, we will see a lot of times that once an inspector conducts a visit to a particular mine, that the mining company will be at the receiving end of possibly a Section 54 instruction being issued, or alternatively a Section 55 order being given. Now, again, just to look at that again against the background of the vaccination process, a Section 54 instruction can only be given if the inspector has reason to believe that there is an occurrence, practice, or condition at a mine that endangers or may endanger the health and safety of any person. And what we've seen in practice is that the inspectors will arrive at a working environment at the mine, and they will assess the mine's compliance against their own code of practice. They will also look at the code of practice and make sure that it's in line with the guidelines. And obviously, at this point in time, it's going to be important for the mining industry to also reconsider their codes and to align it with the most recent developments that take place, and the most recent guidelines that come out from the Department of Health, and then also to start, as part of this risk-based approach, to also bring in the vaccination process as also one of the measures in order to deal with and mitigate and manage the spread of COVID-19 at working places. Just as a last point, like in terms of Section 55, the inspectors can also order compliance with the Mine Health and Safety Act if the inspector has reason to believe that the employer has failed to comply with the provision of the Mine Health and Safety Act. At this stage, there is no requirement in terms of the Mine Health and Safety Act, for instance, to vaccinate employees, but that will be determined through a risk-based approach that will be followed. And it's against that background that the conduct of the mine will be considered. Thank you, Ntsiki. I'm just over my 10 minutes.
Thank you very much, Peter Colleen, for your presentation. I will now present to you Balindile Shezi, a partner in our employment practice with a particular focus in the mining industry. And she will share with us this morning on whether it's compulsory for the COVID-19 vaccines, or it will be optional for the employees, and whether the employers could dismiss anti-vaxxers. And could this be deemed to be an unfair discrimination? Over to you, Balindile.
Thank you, Ntsiki, and good morning. So as Ntsiki has alluded, one of the issues that is consuming that is taking center stage in the arena of employment and unfair labor practice, and labor, is whether or not employers can compel their employees to take the vaccination. This is, of course, a deceptively complex question, and I have the challenge of trying to speak to it in only 10 minutes. So with that in mind, what I've decided to do is focus on just a few issues that feed into this question. And that is essentially, is a policy calling for mandatory vaccination valid and reasonable in the context of employment law? And what are an employer's options if employees refuse to comply with a policy should an employer be minded to implement such a policy? And finally, what are the risks associated with those options that are available to the employees? So put differently, to the employers. Now, Willem has, as part of his discussion, alerted us that, from a Mine Health and Safety Act perspective, employers have the duty to provide a safe working environment in as far as it is reasonably practicable. So that then gives rise to the question: would a mine have an obligation to, as Willem has suggested, would a mine have an obligation to have a mandatory policy for vaccination? And the answer to that, as Willem has already stated, is probably not. But most importantly, then the question then arises in the fulfillment of its duties. Would a rule requiring all the employees to be vaccinated be valid and reasonable? In our view, one has to strike a balance between the individual's rights as is enshrined in the Constitution, that being, the various rights to bodily integrity, the rights to religion, belief, consciousness, and opinion. All of those rights have to be balanced against an employer's duty to safeguard health and safety in the workplace. So in that balance, what we think is probably the appropriate factors to consider is, one has to take into account the rate of infection in a particular workplace, including with the surrounding areas, the rate of death, the ability of employees to work remotely, which for the most part in the mining industry is limited to a handful of employees, the number of vulnerable employees in a particular workplace, the effectiveness of PPE, with the health protocols that have been recommended or prescribed in terms of legislation. How effective are they in the management of COVID-19? What is the exposure to the public of the employees? And most importantly, what is the number of employees who are likely to object to taking the vaccination on the basis of religious beliefs, medical reasons, or any other ground that could justify such an objection? So in balancing all of those factors, what we think is probably something that ought to be considered is we've been living probably with COVID-19 for close to a year now. And many of the mines have been managing the infections and monitoring it with some relative success. And a lot of the mines are managing to deal with infections quickly and efficiently. So the question then becomes, if there has been that relative success, why is there a need to compel employees to take vaccinations if there are other less of intrusive measures of achieving that same purpose? And it may very well be that on an assessment, it is determined that yes, we've been managing to monitor COVID-19 and to manage infections and to prevent infections, etc. But that has been coming at a great cost, and that a continued spending of that cost, be it risk to actual health of individuals or from a commercial perspective, might actually place the sustainability of an operation at risk. That might very well be one of those factors that are put into the basket, and it might end up being an overriding factor. But the only way to actually come to a conclusion, I think, as to whether or not in your particular workplace it is appropriate to introduce such a policy, really depends on the factors that are prevailing in your circumstances, and you must look internally at your own facts. There's not going to be a one-size-fits-all approach. Similarly, you might also have to look at the different categories of employees that you have within your workplace. It might well be that you need to have different rules and requirements for employees who are on surface, employees who are underground, and employees who work in the healthcare facilities. It might well be that there's an argument to be made, particularly with employees who work in the healthcare facilities, that it is an inherent requirement of their job that they become vaccinated. But when one is engaging with what an inherent requirement of the job is, one must pay attention, I guess, to what it really means. And ultimately, what it really calls on an employer to determine is this something that is intrinsically linked to the employee's performance of their duties, such that if this does not exist, they are unable to perform their duties or unable to perform their duties adequately for the case. If it doesn't fit in within that definition, then probably you will not be able to rely on that as a reason to compel employees to take the vaccination. So what happens then if an employee, say, is Actually, thank you very much, dear employer. I see your policy, but because of my religious beliefs, no, thank you. Or because of my medical reasons, because of the side effects of the vaccination, because of the unknown risks of taking the vaccination, I actually will not take this vaccination. What is it that an employer can do? Because of the sensitivities surrounding this issue and because of the nature of the issue, my view is that in the first instance, an employer needs to look to see whether or not they cannot accommodate this employee. And accommodating the employee can vary depending on the circumstances. And in my view, that would range from strengthening the health protocols. Can social distancing assist? Can the employee work from home if that is possible? Can an employee work in a different section to others? Now, by and large, for underground workers, that might not be a possibility given that they work in crews, etc., etc. So one would need to look at it, and only if one cannot accommodate an employee, then they may look to dismissing an employee. But dismissal is going to be a very challenging action to defend unless you have the right circumstances and an employer has invested appropriately into the investigation and is armed with appropriate and fitting empirical evidence to demonstrate that dismissal is appropriate. I see our panel administrators looking at me. I'm wondering if I'm out of time. So if you can just raise your hand for me and say if I'm out of time. I've forgotten to manage my own time. Okay, perfect. So I will quickly then look at the issue of unfair discrimination. The question that we need to address is, as we all know, in terms of the Employment Equity Act, an employer cannot be subjected to occupational detriment on any of the listed grounds of unfair discrimination. And the grounds listed in the Employment Equity Act by and large mirror the grounds listed in the Constitution, which would involve, again, the right to bodily integrity, religion, belief, consciousness, etc. So, and also similarly, in terms of the LRA, if an employee is dismissed for any of these reasons, that would constitute an automatically unfair dismissal. So the question then becomes, what would be the employer's exposure to claims of unfair discrimination, as well as claims of automatically unfair dismissals if it had a policy of this nature? We've already looked at what an inherent requirement of the job entails. If you can establish that it is an inherent requirement of the job for the employer to be vaccinated, you would have a good defense. If you are unable to establish that, you will then have to rely ultimately on an argument that the policy is rational, not unfair, or is otherwise justifiable. If you can't prove those things, in all likelihood, you would be exposed to an unfair discrimination claim or a claim for automatically unfair dismissal. So I think, let me leave it there for now, mindful of time, and I will address the rest of the issues during the Q&A session. Thank you, Nseki.
Thank you very much, Balindile, for your insights. Our last speaker for this morning is Alte Richards, a partner in the corporate commercial practice with particular expertise in the healthcare sector. She will give us an update on the vaccine rollout and the funding. Over to you, Alte.
Thank you, Nsiki, and thank you to all the many people who have joined today. 10 minutes is not a long period of time to discuss issues relating to the vaccine rollout, but we'll do our best. And as you'll have seen, basically on a daily basis, additional information is coming forward from government in terms of its plans for the vaccine rollout. And so just to sort of take a step back, I think where a lot of the concern has come when South Africa looks at other countries, or South Africans look at other countries, They see the sort of delay in us receiving vaccines. There's not always a lot of information coming from government. And so there's been a lot of consternation around whether South Africa is being left behind, and what are the plans that are being made in terms of the vaccine rollout for South Africans. In terms of what I'm going to cover today, just to give you some background, I mean, obviously as ENS, we've been working with a wide variety of clients, both on the pharmaceutical companies, medical schemes, the Solidarity Fund, and on business, including mining companies, that are all obviously very interested in how this is going to carry forward. Basically, quite early on, government took the view that it would be the sole procurer of vaccines for South Africa, and that there's a social, economic, and moral sort of imperative for there to be a collaborative partnership between the relevant role players in order to achieve herd immunity for South Africa and therefore economic recovery as well. So the key role players are really government, also medical schemes, business, including mines, and then healthcare practitioners, pharmaceutical distribution providers, etc. And each of these role players on their own would be unable to achieve herd immunity for South Africa. And so that's why there sort of has to be a coordinated collective strategy to reach sufficient vaccination coverage. I mean, I know from a lot of private sector companies and medical schemes, the indication is why should we need to procure from government? But I guess if you look at medical schemes, for instance, and the number of adult members of medical schemes, which is around, and beneficiaries, which is around 8 million, even if you were to tomorrow import vaccines as private entities, if that were legally possible, which it isn't currently, you would never be able to reach herd immunity for South Africa with only those having private medical scheme coverage being vaccinated. So it really, the principle is that it needs to be a concerted effort between government and the private sector as well. I'm sure you're aware, there is a constitutional right to access to healthcare in South Africa, but built into our constitution is the principle that government must take reasonable legislative and other measures within its available resources in order to achieve progressive realization of that right. So there's no automatic right to say, well, government must just pay for everyone's vaccinations. One of the reasons for government, as we understand it, coordinating national procurement is that, whether it is the vaccines that were secured through the COVAX initiative or through the African Union initiative, or in terms of bilateral discussions with pharmaceutical manufacturers, in general, those other entities are only willing to negotiate and enter into contracts with government. Where there's already a national health system, like in the UK or in many countries in Europe, Canada, then this is something that's very well accepted and known that it would be government as the procuring entity. Here, where we do have currently a two-tiered system, prior to reaching a point of national health insurance, it does seem unusual that government is procuring on everyone's behalf, but that is really how many other countries have been doing it. And I think the other thing that is probably a little bit unfair is, just in terms of our coffee discussions with colleagues over coffee, etc. The easy thing to do is to say, well, Australia pre-booked, millions of doses of vaccines. Israel has already given a first dose of the 2-dose vaccination to over half its population. But those are actually, I think if we're honest with ourselves, those are quite unfair comparisons. I mean, if you look, let's just use the example of Israel first. I mean, it has a population of 9 million versus South Africa's 58 million. Has a very similar gross domestic product number. But when you work that out on a per capita basis, the GDP per capita in Israel is about 2.5 times what it is in South Africa. So we're looking at a richer country with more resources and a much smaller population, was obviously able to move much more nimbly than South Africa. And Australia, also being a wealthy country, in terms of its procurement, its prepayment or deposits that were paid for vaccines, approximately 40% of those vaccines, because they paid these deposits at a time when those vaccines had not gone through all of the relevant clinical trials, about 40% of what they've paid for is unusable. And from a financial perspective, South Africa simply was not in a position to be able to pay deposits on the basis of sort of a bet that these vaccines would be able to be used for our population. So basically, as we understand it, the plan for South Africa now, you will have already seen that 1 million doses of the two-dose AstraZeneca vaccine that was manufactured by the Serum Institute of India have already arrived. And this is now going to be the first phase of the sort of priority levels that have been set by government in discussion with the private sector and medical schemes to prioritize health workers in the first instance, and then move to other essential workers and people of over 70 years of age, and then move down to sort of the 60 to 75-year age group and other people that are at high risk. And then we'll move to the balance of medical scheme members, and then the balance of the adult population that is not covered by medical schemes. So it will be a progressive access to the vaccines that become available. And that'll the current plan is for herd immunity to hopefully be achieved by the end of 2021 in South Africa. Now, there's obviously a lot of challenges that many of you would have be reading about. All the current information that we have in relation to the efficacy of the currently approved vaccines that are internationally approved they're efficacious against the South African variant, but less efficacious. So work is being done now in relation to some type of perhaps a booster shot or a vaccine that's adapted to deal with the variants in Brazil, South Africa, the UK, the US, etc. So it's not without challenges. And the other challenge that we've seen in dealing with clients is that many jurisdictions have a no-fault compensation system where there's been emergency development and approval of vaccines. The US is a good example of that, but there are a number of other countries that also have that type of regime. So if there is an issue in relation to the vaccine, other than due to the fault of the manufacturer or the intentional the failure to meet specifications by the manufacturer, then like a claim against the RAF or the COID fund, your claim as a patient would be against that fund rather than against the manufacturer. And so that protects the manufacturers from an element of liability in circumstances where, rather than taking 15 to 20 years to develop a new vaccine, which is the norm, this has all been done obviously over the course of less than a year. So we haven't reached that point of having a no-fault compensation system in South Africa. It's unclear at this stage whether that will prevent us in accessing certain vaccines due to the position that manufacturers take. But clearly we're now sort of on the road to getting the vaccines to come into South Africa. But I don't think, aside from this first batch for health workers, there probably won't be more vaccines until Q2. What you also may have read is that Johnson & Johnson, or their pharmaceutical arm, Janssen, has entered into an agreement with Aspen locally, so that Aspen won't manufacture the vaccine per se, but will do some of the local packaging, maybe preparing of vials, etc. So some of that will be done locally, which obviously also supports local jobs, etc. Because in many ways, the J&J vaccine, because it's a single dose vaccine that has to be stored under normal refrigeration, it's probably a more ideal solution for a country like South Africa, where you have a lot of people also in rural areas, where you have the urban areas with quite a good infrastructure, but many areas that don't have good infrastructure in terms of cold chain and cold storage. You might have also seen that the government has secured 20 million doses of the Pfizer vaccine. But as you'll be aware, I mean, that needs to be stored at -70 degrees Celsius. So that, creates issues and may only be able to then be distributed in very controlled circumstances, where if you can move to a single dose vaccine or even the AstraZeneca vaccine that can be stored also just in normal refrigeration temperatures of 2 to 8 degrees Celsius, it's probably more appropriate for the South African context. So there's obviously a lot more that we could cover, and and I'm hoping a lot of questions will come up as well. But I think that's where I'll leave it in terms of the broad overview of our understanding of where the government sort of policy is coming from and the direction that we're moving in. But I'll hand back to Nsiki. Thank you.
Thank you very much, Alte. That was really insightful. And thank you to all our participants for posing your questions in our Q&A box. And just a reminder to the rest of the participants who are still interested in posing questions to do so. We'll start with the first question. And I think this one is for Balindile. If a company decides to introduce a policy for mandatory vaccination, does it need the employees' consent?
Thank you, Nsiki. So
Balindile?
Yes. So from there are two schools of thought on this. I've heard views that in the introduction of the policy, an employer must consult and obtain the consent of the employees prior to introducing such a policy. In my view, I agree that you would need to consult because of just the nature of this type of policy. But I'm not aligned with the view that you would in all circumstances require the consent of employees. If you are dealing with a situation where you have a term and condition of employment, be it in your contract of employment or in collective agreements, which speaks to an employer's obligations to, or rather an employer's rights to compel employees to be vaccinated, then you would be talking about a different story. I'm not aware of a contract of employment which has those express terms, but perhaps if you have something that can be interpreted to suggest that you would need to engage with employees to get their consent, because not to do so would constitute a unilateral change to terms and conditions of employment. In my experience, most of the contracts of employment in the mining environment are fairly old, and they would not have clauses to that effect, typically speaking. So if that's not the case, I think that it would be sufficient to consult with the employee body, and if you can get consensus, great, but if you don't get consensus, I think it will still be appropriate for an employer in the right circumstances to then institute such a policy. The ultimate test is going to be whether you have meaningfully consulted, and number two, whether the actual policy, taking into account all the factors and issues I discussed earlier, whether or not it is valid and reasonable. Thank you, Nsiki.
Thank you, Balindile. Okay, so I'm going to read the next question, and I'm posing this to our panelists. The term through ventilation is used loosely to describe some control that can be implemented for the working environment, specifically offices, to reduce the risk. However, is there any guideline or standard that can be used to guide the environmental practitioners on how and how much through ventilation is required? In my opinion, split air conditioners will not assist in through ventilation, but rather assist in recirculating the air in the room. Panelists, any of you that wants to take that question?
I will deal with that, Nsiki. I will deal with that.
Okay, please go ahead, Willem.
Yeah. Can I just add, in regard to the previous question and answer, we must also keep in mind Section 8 of the Mine Health and Safety Act, which compels an employer to establish a health and safety policy and to consult with the Health and Safety Committee on that, and also on the not only the preparation, but also the revision of that. So the better way perhaps to deal with the question of vaccination will be to regard that as a practice flowing from the health and safety policy. Okay, let me deal with the ventilation question. Thanks to Kobus Dekker for posing that question. Kobus himself an expert on occupational hygiene. Now, there is no guideline that I know of which prescribes what specific level there should be of through ventilation, you know, in terms of concentration or percentage. The only requirement that we have in the Mine Health and Safety Regulations is, of course, contained in Section 9, read with other sections of the Act, like Section 11 and Section 12. Now, Regulation 9 deals with the airborne pollutants, which prescribe to what extent you can't exceed the airborne pollutants, for example, CO, CO2, silica dust, and so forth. So, Kobus, at the end of the day, it will depend on your risk assessment, whether you provide sufficient fresh air to people to work without endangering their health or safety. Thank you.
Thank you so much, Willem. Moving to the next question from Kerusha Pillay, says, kindly advise on the liability, if any, that the mine may attract in administering the vaccine to its employees. I suppose all she's asking here is that, will the mine be protected from the claims?
Nsiki, I can take that one.
Okay. Thank you, Alte.
So, I mean, it's an interesting question, and a lot of this depends on the basis on which, you know, if the vaccines are ultimately going to be registered, or if government brings them under Section 21, liability. The answer is it depends. But if we actually look at in terms of mines using their own existing infrastructure, doctors, nurses, in order to administer the vaccine ultimately, again, that would never include the liability for any manufacturing defects, any lack of efficacy of the vaccine itself. The liability there would be in the same way as a doctor or a nurse, and in this case, you know, if they're employed or contracted by the mines, if a doctor or a nurse, you know, acts negligently in the administration of a medicine or in the giving of an injection, there can be a liability around that if this is done in your hospital or your clinic. But it's not going to relate to the efficacy of the vaccine itself. So there's no additional liability in relation to the efficacy of the vaccine, because presumably SAPRA will either approve it or government will bring it in under Section 21, and then the manufacturer or government would then be liable in that case. So I mean, the only exception, I suppose, that would be is obviously if you've got a vaccine that needs to be maintained at -70 degrees Celsius or -40 degrees Celsius until the time of administration, and you take on that responsibility as the institutional pharmacy, you know, in a mine hospital or in the pharmacy connected to a clinic. I mean, then if it's due to the fault on the part of the handling or storage of the vaccine, then there could be liability in that scenario. Not in terms of when it's being distributed to the pharmacy, but obviously if the fault occurs at the pharmacy because it's not properly maintained, then potentially there could be liability there. But the general position would be no different than the normal liability of a doctor or nurse when giving medication or administering an injection, for which presumably many hospitals and doctors, hospitals covering also the employed nurses, and then doctors in their own capacity as independent contractors would have some type of professional insurance in that regard. So I don't know, Peter, if you wanted to add to that. I saw you did have your hand up earlier.
I think an important consideration as well, I've mentioned that a lot of mines do not only have occupational health facilities, that deal with occupational issues within the environment, but also primary health care, where there's hospitals and clinics that then also support surrounding communities. And I think it's advisable, I know that as part of the process, consent have to be given for the vaccine, and maybe to build into that consent also some type of indemnity just to protect the mine, if it's then done as part of a process where government is supported with the vaccination process and possibly wider than the mine's own employees. But that's just a comment from my side.
Thank you very much, Peter. I will now take Nomin Ngumalo's question. Can an employee refuse to work side by side with an employee who chose not to be vaccinated due to any reason, including religious reasons? In that case, can the employer take any disciplinary action against such an employee?
Thank you, Nzigi. I'll take that. So I think there are a number of considerations in answering this question. The first question, I guess, would be whether or not the employer in this case has a mandatory vaccination policy. And if it does, what has been the reasons giving rise to that particular employer implementing that policy? Is it because the employer has found that the health protocols are insufficient in the workplace to ultimately provide a safe working place? And if that's the question, then if an employee refuses, the employer would have to engage that employee and would have to deal probably with the employee who has not been vaccinated. But ultimately for me, the question is this: notwithstanding an employee not being vaccinated, can it be said that the workplace is safe and as far as it is reasonably practicable? If that is the case, then I don't think an employee will be free to refuse to tender their services because their colleague has not vaccinated. So that would be that's my immediate sense of how that question or that issue ought to be addressed. Of course, it might well be that the best chance or that an employers have is educating their workforce so that they know, why is it that people must be vaccinated and what are the consequences of not vaccinating on a particular workplace, so that there's clarity as to whether or not it is safe for employees to work, even though some of their colleagues may not be vaccinated, which will very well be the case because there could be valid reasons why employees don't vaccinate. Thank you, T.
Thank you very much, Balindile. I'm going to, I think, take 2 more questions so we can close. This one is from Dineo Poshoko. What would be the best way to approach a vaccination program in the mining industry in a neutral manner for both employers and employees? Anyone interested in taking that one? Okay.
let me attempt that one. I think it ultimately comes down to the balancing exercise that I spoke about earlier on. Looking at what are the competing interests, both for the employer as well as for the employee's own individual rights. And if it is at the end of that analysis determined that it is in the interest of the employer's business as well as the health and safety of the employee population for vaccinations to be mandatory or for vaccinations to be taken, then that would be the overriding, I guess, principle or policy in that particular workplace. But if it's not mandatory because it doesn't adversely affect health and safety, or it doesn't pose operational requirement threats to a business, then it might well be then that the employer adopts a more voluntary basis, vaccination basis, and just promotes the taking of vaccinations in its workplace. Thank you, Ziggy.
Thank you very much, Balindile. There's a question from Chantal Kukurmoor. Follow up on vaccine question. If allergic reaction are experienced and an employee passes away, will this be an occupational fatality or liability to the mine?
I will deal with that, Mtsiki.
Thank you very much, Willem.
Yeah. Whether or not it will be a dangerous occurrence or an accident that must be reportable depends on the fact whether it is work-related. If it's work-related, then it must be reported. And so then it will be part of the fatal statistics of the mine. Thank you.
Thank you very, very much. Now, from my side, I just want to thank all the participants for joining us this morning, and to thank all the organizers, Desiree, Dumi, and the distinguished panelists that we had this morning for sharing their insights. And we look forward to hosting another webinar, and we hope that you have a great day further. Thank you so much.
Thank you, Mtsiki.
Thanks very much, Mtsiki. Well done.
Yeah, thank you, everyone.
Thanks, all of
I
you.
just forgot to tell people that their questions, we might be able to answer them because people had their name. I think it'd be nice to go back to your client.
Abuse.